Good morning, everybody. Thank you so much for joining us today. I'm Nikki Jovicic from LookUpStrata, and I'm also the Managing Director of Tower Body Corporate, a body corporate management company in Queensland. I'm the host for today's session, and for today's Queensland webinar, here we are again with Frank Higginson from Hynes Legal. This webinar aims to educate people living in strata and professional strata managers about the crucial difference between maintenance and improvements. Led by Frank Higginson, we'll explore the definitions and characteristics of maintenance and improvements, understanding how these classifications apply to lot property and also to common areas. The session will highlight the significance of the distinctions for lot owners and the body corporate, emphasising how decisions regarding maintenance and improvements impact property value, legal and financial considerations, and the overall harmony of strata communities. We'll also be looking at the spending limits that apply to each. I'd like to mention that this is a Queensland session today, and while many of our sessions are applicable in other states, for this one, it's tied closely to the Queensland legislation, so probably a lot more applicable just for Queensland. Now, before we begin, I'd like to mention that the information in the session today, including the discussions arising from submitted questions, is not legal advice and should not be relied upon as legal advice, and you should seek independent advice before acting on the information contained in this session. Now, today we're welcoming back Frank Higginson from Hynes Legal. Frank heads the community titles practice at Hynes Legal. Frank commenced 5 years articles of clerkship on the Gold Coast while studying law externally in the early 90s. And apart from a 2-year hiatus working in London with a multinational firm in the late 90s, he has practiced in Queensland in property matters for his entire career. Frank joined Hynes Legal in 2001 and became a partner director in 2004, and has whittled his practice down to 2 key areas for strata law in Queensland: body corporate law and management rights. He and his team are the only experts in Queensland that truly specialise in both of these areas of law. And the rationale for this is the belief that when there is issues in dispute, it helps enormously from a legal and strategic and commercial position to understand the strengths, weaknesses and views of the other party. And it creates the opportunity to make commercially sensible suggestions to enable the resolutions of all issues in dispute. Now, Frank has responded to questions from LookUpStrata's Queensland body corporate audience for many years. Hynes Legal has contributed to LookUpStrata since the beginning of our Queensland Q&A service, and you will have seen content from Hynes Legal regularly in our newsletters and also the Queensland Strata magazine. And we have great pleasure in welcoming Frank back today. So Frank, thanks for joining us.
No worries, Nikki. Thank you for having me again. So today, maintenance versus improvement. So as Nikki said, this is a very Queensland specific section or session. Hand on heart, I don't know what happens in other states because we don't practice in other states, but I know in Queensland, and I suppose it's sort of one of those things, you look at it and say, why is it important? Because wars are fought over this stuff, because there's different thresholds and different requirements in relation to whether something is maintenance or whether something is an improvement in a body corporate. So I know we're in the midst of a legislative reform process. Hopefully at some stage in the not too distant future, we will see the draft legislation on termination of schemes and what they're doing about bylaws and all that sort of stuff. But for the time being, this sort of topic today is still a source of substantial dispute in the Commissioner's office, believe it or not. So I think there's some very basic ground rules that if everyone can come out of this today, understanding some of the basics, it will help in resolving questions and differences about these things. Because I'm dead set, the more I do this, the more I think a source of a lot of the disputes is people simply not understanding what the law is or what the legal position is. That's a large part of the problem. People go off, maybe that's a strong word, people entrench the position or take a position based on what they think things should be or what things are, and that's incorrect. And that's where the fight starts, because we're not even fighting about the right thing. So, and then 6 months later, when we get engaged or have a chat with someone about it, positions are entrenched, everyone hates each other, and on you go. So helping understand the basics, I think, is a really important thing. And this is a bit of a back to basics ones, but there is some detail there for those of you that are full strata nerds. So stay tuned. So today, maintenance versus improvement, what it actually is. And then for me, and this is, I suppose, the important things, how those definitions and the legislative position apply to both lots and to common property, because they're two different things. It's about owners improving lots, and it's about owners improving common property, and body corporate improving common property. It's very rare to see a body corporate improving an owner's lot, which won't really happen, but they're the context in which these questions come up. So If you walk out of here today remembering this, it's great. But I think really important, this is the starting point. Our legislation, to the best of my knowledge, I don't think any of this is going to be dealt with when we get revisions to legislation in due course. So this is status quo. Our BCCM Act defines improvement, and it's those things: erection of a building, a structural change, a non-structural change. So that is obviously very wide. You know, it's not as specific as an example of some things you could do. Haven't seen too many bodies corporates erect buildings, maybe some sheds and whatever it might be. Structural change probably speaks for itself, and non-structural change is really the catch-all where most of these things might otherwise be dealt with. And 1 second, really air conditioning because it's warm. And so that non-structural change is obviously a very wide thing to take into account. So that's what the Act says an improvement is, and maintenance is not defined. So in that sense, where we get back to then is dictionary definitions. So you would expect, and as has been the case, I mean, adjudicators have now been around under the BCCM Act for a quarter of a century. So if you go and put that into OSLI and search maintenance versus improvement, you will have a raft of decisions come up. But for me, this is the one that I probably come back to more often than not when we're giving clients advice on these particular issues. And this is from an adjudication. There's a lot of them that are consistent with this. So I'm sure all of you can read, but for those of you that might be listening to this at some later stage, it seems to me that the test, so far as one can give any test of these matters, is this: if the work which is done is the provision of something new, that's an improvement. But if it is only the replacement of something already there, which has become dilapidated or worn out, then albeit that it is a replacement by its modern equivalent, it comes within the category of repairs, in other words, maintenance, and not improvements. So that is, for me, it's probably taking away, in a sense, what those legislative definitions or non-definitions for maintenance and applying that. So that, to me, is as good an example of the difference between the two that you're going to get. And I think if you want to step it down one more, for me, is it like for like? So for me, the test then becomes, if there is work being done on common property or on common property by a body corporate or a lot owner, or is the work replacing something that's already there with something that's like for like, or is it putting something new in? That's the thing to remember, and I'll explain why through the course of this presentation, why that actually matters. But like for like is really important. And the reason I've pulled up that particular adjudication, the adjudicator acknowledged there that the replacement of something might be with something new, which is its modern equivalent. So if you're going to take the example I always use for this, because again, it's not the first time I've spoken about this, we got a fence on common property. That fence is a timber slatted fence. We need a new fence. If that fence is replaced with or repaired, maintained with the same style of timber slats that were already there, then that is maintenance. And that's back to our statutory obligation to keep common property in good repair and condition. If that fence is going to become chain link or galvanized steel or rendered brick or whatever it might be, that's not maintenance, that's an improvement, because that's not like for like. That is a change. So it's still a fence, but it's a different type of fence. Probably the prime example, and probably the first time I came across this distinction, was repainting of a building. So my building here in Brisbane, relatively big one, lots of disputes, lots of owner occupiers, lots of people with opinions. And that was one where the body corporate, for those of you who might be 12th Man fans, you remember, Richie of the beige, the off-white, the bone, the china, the cream, whatever it might be, in terms of jackets. The building was painted a certain color. The body corporate, the building needed to be repainted because paint, as we know, happens. The body corporate wanted to go and change it from cream to beige. The repainting was maintenance, but the change of color was an improvement because it wasn't like for like, it was a different color. So that's the sort of things that these actually turn on. So another example might be a lift. We've got a lift, it's been there for 15 years. It needs a particular component replaced. what was there when the thing was put in 15 years ago is no longer available in the market, but the replacement for that thing is this particular component. That, based on this definition, is going to be maintenance, because what we've got is we've got to keep our common property in good repair and condition. The only thing available to replace that broken component is this new thing, but that's what it is at the moment that is capable of replacing that. What was there is no longer there. So that then becomes maintenance. And so the distinction there between that and the fence example at the start is you're changing the style of fence as opposed to replacing the fence. You know what I mean? So it's not, I suppose, and sometimes I sort of tend to oversimplify these things, because to me, when you do them often enough, you sort of look at them and go, well, bang. They're really important distinctions. Because when you come to say the color of a building, that was a massive fight. So is it like for like? So if you want to walk away with one thing from this session, is it like for like, is the first question you need to ask yourself when you're talking about works on common property particularly. And if it's not, then you might be in the improvement zone, and that starts to become important as we get through this thing. So probably lot owners. So lot owners, and I thought I'd just cover this because it's not necessarily the same topic, but it's related to it. So again, I've referenced the standard module here. There's equivalent provisions in the accommodation module and the commercial module. So this is statutory. So this is what lot owners are obliged to do with respect to their lots. So you don't need this in your bylaws, and that's a constant conversation I have with clients. You know, what about, we want to put this in the bylaws? You don't need in the bylaws what the statutory provisions are, because starting point is, where do you start and finish? How much of the legislation are you going to pull in? And then more importantly, what happens if the legislation changes? Now, I don't think this provision is ever going to change, but that's not to say you should put it in your bylaws. So anyway, so lot owners must keep in a clean and tidy condition parts of the lot readily observable from another lot or common property. So we're talking about backyards, front yards, I suppose, porte cocheres, those sort of things at the front of yards. It's certainly not 15-year-old children's bedrooms like my daughter. That's a constant mess. It's not capable of being seen from outside. So what my daughter does in her room is completely up to her in terms of the untidiness. They must maintain their lot in a good condition. So again, that's back to letting weeds and gardens get overgrown. You know, my wife watches a lot of the hoarders stuff you see. I haven't really had many hoarders questions, but hoarding would be an example of potentially not maintaining a lot in a good condition. And then the last point, maintain a good condition, the utility infrastructure, so pipes, whatever it might be, within the boundaries of the lot, not part of the common property. And if that utility infrastructure is in need of replacement, replace it. So those are all statutory, and there is nothing more bodies corporates need to do other than understand that's what owners' obligations are. Now, of course, you can have disputes about what is good condition, all that sort of stuff, and those things can be a little bit subjective, but that's where it starts for lot owners. Now, lot owners improving their lot. So usually this is part bylaws, part statute. So if you want to improve your lot, and also it depends in part on what type of plan format you're in. You might be a building format plan, i.e. in a high rise, or you might be in a townhouse where you might be a standard format plan, which means you effectively own the block of dirt on which your property is built, and the structure on that is completely and utterly yours. So those factors colour what bodies corporates can do about these things. But I suppose the starting point for me is that once you get inside a front door, largely becomes the owner's domain. Now, that's particularly the case in a standard format plan, which is the one where you own the land and all that sort of stuff. Obviously, it's a little bit more coloured in a building format plan where you might be up on the 13th floor and there's going to be pieces of infrastructure, you know, pipes, electrical cables, whatever it might be, that are common property that service the lot that are going to be affected potentially by any renovation. But where it gets to from my end, owners can't interfere with utility infrastructure. Bylaws should drive owners towards bodies corporate for approval before they commence any renovation works. And in high rises, obviously hard flooring is a big part of that, but you know, substantial renovations are part of that as well. And then bodies corporate can condition approvals based on reasonable conditions. And again, these don't necessarily be in the bylaws. These can be guidelines based on whatever the building specifics might be. Inside these hours, workmen must do this. We'd like to see insurance, you know, clean and tidy, doing this, you know, et cetera, et cetera, et cetera. So Where I certainly get to with those approvals about bylaws or approvals about renovations, it's much easier to ensure owners know that before you do any works to your lot, you come and talk to us as a committee, and we'll then be reasonable about making sure you know what the rules are and that all of the things you need to be aware of from a body corporate perspective are dealt with. That is much better than trying to incorporate all of the rules that you might possibly have into the bylaws themselves, because that is trying to cover the whole building from start to finish. And there is absolutely going to be things that you forget or apply or don't apply, subject to the style of unit and the type of renovation that's going to be sought. You know, for example, hard flooring might be the conditions that you might want to impose in relation to that on a penthouse are going to be different to those on the ground floor, obviously, because there's no one underneath them. So having the same specifications when someone underneath is not going to be affected might not necessarily be reasonable. So just, again, that's not today's topic, but it's more about reasonable conditions will be imposed. But you've got to remember, once you go inside that lot, same as you've got to paint the feature wall in your bedroom pink. No, that's not for the body corporate to interfere with. That's up to the owners to decide what they want to do. But when it comes to infrastructure, external works, how it might affect other people, causing nuisance, that's where the committee can absolutely be involved. So that's lot owners' improvements to their lot. Now we'll talk about lot owners' improvements to common property. And this absolutely happens. So first thing, and this is the distinction that is really important, is that exclusive use grants or grants of exclusive use, those areas are still common property. Even though the right to use them has been given away exclusively to the owner of that particular lot forever, without any further action on anyone's part, that's what's under the bylaws, that area is still a common property. So we're going to see that in car parks. We're going to see that in courtyards and front yards. I mean, they're your two prime examples. So, and the Act creates a distinction between the rules around whether the common property is a grant of exclusive use or whether the common property is pure common property over which no grant of exclusive use is in place. So if it is a grant of exclusive use, so if an owner does have the right to use it exclusively, this is the condition. The committee can approve the cost of the improvements if the spending on them is less than $3,000. Now, again, this includes GST, randomly enough. And there is a question there later on, and that includes, the Act's pretty specific around trying to avoid, I suppose, the overall spending limit by breaking things down into individual components, saying this is $2,000, this is $3,000, this is $8,000. The Act will say, no, that's a $13,000 project. That's what's being spent. So if it's exclusive use, there it is. So if we're doing a little upgrade to our backyard, we're putting in some gardens, we're doing something out the front, whatever it might be, that's where the committee's limit starts and finishes. If it's more than that, we're off to general meeting. If the area of common property that's the owner wants to improve is not exclusive use, we've still got that same $3,000 limit. There's another condition that the improvement does not detract from the appearance of a lot. So again, that can be a tiny bit subjective. And that last point, body corporate satisfied that the use and enjoyment of the improvement is not likely to be a breach of the owner's duties of an occupier by causing a nuisance to others. You know, so maybe we're installing a disco ball above our common property yard or something like that. I don't know. I haven't had a dispute on that sort of stuff, but those are the conditions that then need to attach. And again, from a body corporate perspective, if you're on a committee, it's really important to remember that just because the committee can do something doesn't mean that it has to do that thing. So from my perspective, if an owner made an application and the committee's thinking about, well, we're not sure how the community is going to take this, it is completely reasonable to put that up to general meeting for owners to seek to approve it. Now, that's not necessarily going to change the reasonableness of the decision to deny or confirm, but what that will do is take away the obligation of the committee to be the sole arbiter of that particular application. But obviously a $3,000 limit's a relatively minor thing. And it might be, we're putting, you know, we've got a wall on our front boundary of our property in a standard format plan. We want to put a garden bed out on the front of that to enhance the street appeal. You know, so less than $3,000 probably. improvement does not detract from the appearance of a lot, and it's a lot, not the lot. So to me, how's it look with everything else? So it's all these things need to go into the mix. So again, I suppose Nikki said at the start, this isn't legal advice, and it's absolutely not. These are the rules. How those rules apply to any particular application really depends on the scheme. And when adjudicators retain the ability to make orders that are just and equitable in the circumstances, that's where they can go and look at things and say, well, might be okay for that body corporate, but it's not okay for this one. And that's going to depend on how the whole thing mixes together. And I suppose that's where the legal advice comes from. But those are the rules for lot owners making an improvement to common property. First thing, A, is it an improvement? We've discussed that. Is it like for like? Is it replacing something that's already there? Is it exclusive use or not? And then you drill down from there. Now, and if you don't comply with any of those conditions, you have to throw it to general meeting. But like I said, committee can throw it to general meeting anyway. So it's up to the committee to decide, test the, see what the feel of the building is. Now, body corporate's obligations to maintain common property. And I've played around with our little introduction. So this is section 180 of the standard module, if you're interested in going to that. This is a body corporate's statutory obligation. So again, it's one of the big differences in terms of property ownership is I own a house, I can do what I want with my house. I can let the gutters fall off, I can not paint it, I can let the front yard overgrow. Council might get stroppy, but that might be it. My neighbours certainly will, but it's my choice. Body corporates don't have a choice when it comes to those things. So the body corporate must maintain common property in a good condition, and where things are structural, in a structurally sound condition. Can't take that away. That's what they must do. And so again, countless adjudications about bodies corporates not looking after leaky roofs, potentially not dealing with things that might be structurally going wrong. And when, this is one of those things that happens in strata, there's an illusion of choice. You might put something up to general meeting, which makes you think that you've got a choice, but you actually don't. Because what can happen if a body corporate doesn't comply with that obligation, owners can go and seek the appointment of an administrator to give effect to what is actually required to be done at law. So an administrator is where an adjudicator will say to someone, requested by the applicant, you are now empowered to go and deal with these things. You can strike your levies, you can go and engage contractors, you can do the work, et cetera, to make this stuff happen. So that's not lightly done. There's obviously 1,000 different applications about that as well. And really, the point there that you're going to need to prove to be successful in one of those things is that the body corporate is absolutely refusing to do what the law says it must do. So that's a big part of it. And I suppose first question on that is, motion's gone up to general meeting and everyone said no. So that's the body corporate's obligation to maintain common property. Now, when we're talking about a body corporate's improvements to common property, this is where it gets complicated. So again, remembering, this is not maintenance. This is an improvement. So, like we always have in this Queensland legislation, we've got a raft of potentially competing spending limits. So you won't find this anywhere else. So this is not the spending limit that the body corporate's got. This is the rules around the approval of an improvement. So there's a basic improvement limit, which is $300 by the number of lots in the scheme. So if that's the case, the committee can approve it if it's under that amount. But the difficulty is that sometimes, and most times, the default committee spending limit is $200 by the number of lots. So you might have something in theory that a committee can approve as an improvement, but it still needs to go to general meeting to get approval for that because it's going to spend more than what its statutory rights are with respect to spending. So the first thing is, at what level can a committee approve? And then the second question is, well, can it actually do it based on the current rules? So that in itself is confusing. Don't get caught by that. An ordinary resolution improvement range is more than that basic improvement limit and less than $2,000 by the number of lots in the scheme. So if we've got the body corporate wanting to make improvements to common property, that is, again, from that $300 to $2,000 by the number of lots as the total expenditure, again, remembering these things will be aggregated as a project, that needs to go up by ordinary resolution. and it can only happen once per financial year. So there's not too many resolutions that they stop going up more than once. So basically what to me this is saying is, from a committee perspective, if you want to put something up and you need to seek owners' approval, make sure you've got the lie of the land before you do it, because if you put something up and it's defeated, you're not having a crack at it again that year. Really important to remember. And absent that, it's a special resolution. So if you're looking to improve common property by more than $2,000 by the number of lots, you're off to special resolution to do that. So that's effectively 2/3 of those who voted in favour, then no more than 25% of the lots or 25% of the lot entitlements, contribution schedule lot entitlements, voting against it. So they're your three thresholds: under $300, 300 to 2,000, and then you're away to special resolution. Now remember, and this is a really important thing, the decision to go, so say we're doing an ordinary resolution to improve common property, we want to build a new pool. And that's probably more than $2,000 by the number of lots, sort of how big your building is. We want to build a new pool, we want to build a spa. The decision to actually make that improvement is one thing. The spending and the quoting rules to actually then build that pool are another thing entirely. So remember, we've got the first question, because it's so starting point, is it maintenance or improvement? So we've decided that this is an improvement because we're building a new spa. How much is the spa going to cost? It's going to cost the ordinary resolution improvement range in there somewhere, $1,000 per lot. We want to put up a motion to put a new spa in. The second part of that is to then approve the spending for that spa, which might be 2 quotes and all that sort of thing. So the decision to put the yes, owners want to do a spa is independent of then the decision to spend the money and which contractor they go with. You need to make sure you've got both, because bodies corporates can fall in the trap of saying, yep, we want a spa. Owners said yes, but you haven't dealt with the proper spending limits and budgeting amounts and all that sort of thing. They're 2 separate things and really important to remember. So, yeah, don't forget. No, so oh, there you go, Nikki, I'm almost at the end. So, rules of this thing: maintenance versus improvement. Is it like for like? If it's maintenance, we're just down the path of what's our committee spending limit. We can make this decision. We're not changing anything structural. We're not changing the look of anything. We're not changing the color, not changing the style of fence. It's just purely, it's going to cost us $3,000 to do that. That's a run of the mill. Make the decision. We're keeping common property in good condition. Away you go. If it's not like for like, we're then across to that improvement. And those rules there that I just ran through about the basic improvement limits and all that sort of stuff. Quoting, as I just said before, don't forget the decision to make an improvement is independent of the quoting needs that you've still got. The Commissioner's Office is, I wouldn't say red hot, they're pretty firm on quoting requirements. There's no reason not to have 2 quotes unless there's some extraordinary circumstances. And if most improvement style questions are going to have the ability to get 2 quotes, even in a tough labour market. So you need to make sure that you don't forget the decision to improve is independent of that spending limit. Spending limits, again, now you can't change those statutory provisions around basic improvement limit, ordinary resolution improvement range. They're set in stone. You cannot change those. Otherwise, a body corporate can change the spending limits for quotes for committee at general meetings. So you can give, so for example, this spa, we've made a decision to do the spa. What could follow would be a secondary motion that might say, and that we increase the spending limit for the purposes of this particular piece of work for the committee to $25,000. So at that stage, then the committee's in control of getting quotes, complying with their statutory obligations without having the need to go back to owners in general meeting to say, which quote do you want? So, but don't forget, you can do that. You can do it wholesale. You can do it for specific projects. You could do it for a specific period. Up to you. And that probably creates a bit more flexibility once owners have made that decision to make the improvement. As always, with everything in Queensland, acting reasonably is the most important thing. And where I get to with that, and again, this is from doing a lot of work with Chris Hynes over the years, you've got to be able to explain why. When someone asks you why, You've got to be able to elocute an answer. That to me is probably nothing legal about that in a sense, but if you can't justify why you're doing something, instantaneously to me, it says, well, is that reasonable? So be prepared in a sense to justify your decision making. Why have you gone with that particular quote? Why do we need to do this? Why do we need this type of fence if we're talking about improvements? Why did you impose those conditions? And that's one of the traps that people fall in, you know, and lawyers are good at words, create lots of words with lots of conditions that might go in bylaws. I mean, I've seen renovation approval bylaws that go 3 pages, and yet they still don't cover all of the things that can potentially be covered. And more importantly, they include as a bylaw something that is objectively unreasonable in the circumstances. So then you're caught in this invidious position where the bylaw says you can't do this when the law decided before or after that, from adjudications or otherwise, says that people can. So that's why you want to have guidelines more than hard and fast rules in bylaws, because just having it in a bylaw doesn't make it reasonable. And lastly, and this really ties into acting reasonably, documenting your decision making is really important. And I know from, and again, this is, as I suppose Nikki said in the bio, I think one of the things that we do, well, like for anyone who pays us, I mean, that's lawyers, there you go. I'm not ideologically tied to any particular group. But one of the big things when we're either defending a body corporate position or prosecuting, I suppose, a case that a body corporate's acted unreasonably, is that documentation of the decision-making process or why things were made, particularly if they're going to be contentious, is really important. Because that either gives the committee a position of defence, and if it's not there, it certainly creates the ability for the opponents to that decision to take the body corporate on. Because again, that just and equitable jurisdiction that the Commissioner's Office got allows them to look at things and go, well, that was a reasonable decision. And obviously, what's reasonable can be very subjective. So the starting point is to make sure that you've got the actual reason for that decision that is capable of justification. If you've got that, that's a hell of a lot better than, well, we just made it. You know, that difficulty, and this is always going to be the case, and again, I'm not aware of any prospect of this changing, that statutory obligation for committee to act reasonably really gives the Commissioner's Office the ability to override any decision that a committee makes that isn't reasonable, or a body corporate in general meeting. And that, I think, is something that will always be there, because certainly, you know, some people get in positions of power and don't necessarily do what they should be doing, or exercise their powers for the wrong reasons. And that's that oversight that is always going to be there. And, you know, I suppose in a political sense, we get it every 3 or 4 years where we get to vote our politicians out of power. In a body corporate sense, it certainly happens every year, but in the meantime, that might not be enough for people in the sanctity of their own homes to have what their rights that they should be exercised. So adjudicators are always going to have that right. So there you go, Nikki.
Excellent. Thanks, Frank. That was great. Really great to get into that detail. And I was glad that you were able to offer those examples that you did for the difference between the improvements and the maintenance. I'm sure people found that very useful. One of the things that I wanted to mention, Frank, and it's a little bit off topic again, because it's talking more about the spending limits, I guess, and the well, actually, no, sorry, it's talking more about improvements from lot owners when they're getting their renovations done. If somebody does apply to do something like install a skylight, is there part of the bylaw that they have to look after any maintenance for common property after that point? Is that something that...
Yes, well, that should be a condition of the approval, but it's also in the legislation. So if someone installs something on the common property, the statutory position is that they're responsible for the maintenance of it. And the difficulty we sometimes have is that when that installation might have been 15 or 20 years ago, we don't know who installed it. Did the developer do it, or did the lot owner do it, or did the body corporate do it? So they're messy, because factually you can't, the legislation is relatively clear in terms of where the obligation is, but the starting point is factually what happened. And so part of that is the documenting decision making. But again, 15 years ago, and we're the same now, even from a client file perspective, every email that we get saved into the system automatically, away you go. So I can look at what happened on the 15th of July last year, and there it is. 15 years ago, we didn't have that. So from a body corporate perspective, I think today's stuff will be easier to deal with, but stuff happened 15 years ago is a problem.
Especially if you've got lots of ownership changes during the years and people don't know whether it's been installed by an owner or so it gets lost in the system. For lot owner improvements, the committee approval limit is $3,000. After that, any improvement application should be determined at a general meeting. However, general meetings tend to be too expensive for lot owners to call individually or too far away for most lot owners to wait. The net effect is that many lot owners proceed with the works regardless of approval, or committees are approving works in advance, either outside of their authority or so that they can be approved at the next general meeting. Do you think the current rules are effective and should be strictly adhered to? Otherwise, how should owners and committees manage this situation?
Yeah, okay. It's interesting, and there's a later question here about spending limits as well. All these numbers appeared in 1997 and are still the same numbers 26 years later. So we've had a little bit of inflation since then, and we've also had GST. So because there's no reference to GST in the legislation. So absolutely, I think the amounts probably can go up. I mean, $3,000 buys you nothing these days in terms of works to anything. You know what I mean? It's basically almost a call-out fee for some contractors. But in terms of what to do with this particular stuff, I suppose where I get to is the legislation is the legislation. It says what's got to happen. That's what government's decided should happen. The difficulty, and I suppose this is part of what our new modules in 2021, pre and post COVID, that everything just is a different world now, tried to create with electronic voting at general meetings and that sort of stuff. They're not as unwieldy as what they used to be in terms of postage and the rest of it. But I suppose, so where I get to the legal advice, that's what the legislation says, that's what you should do. The commercial advice would be, if you think owners aren't going to object and a bunch of other people have done it, and it's $3,500 from a committee perspective, just do it and ratify it at the next general meeting. But that's your call. That's not me saying to you do it. That's for you to make the decision, and you've got to be aware that you are not in compliance with the legislation, and someone could hold you to account for that in the sense of no.
Okay, yeah, that's some practical advice.
Yeah, legal and practical, they're two different things.
That's it. All right, we've had a question come in that's saying if an improvement, say a fence, which now has a new gate that was not there before, and it's half owners and half common, does the total cost get halved in working out the spending limit works?
Excellent question. I'd say, well, so you've got, no, off the cuff, I'd say if the gate collectively costs more than $3,000, then that's, well, it's an improvement to start with. So it's definitely putting a gate in as an improvement. If it's more than under $3,000 collectively for the gate, even if only half of it's paid by the body corporate, my gut feel would be that should be, if it's more than $3,000, you're off to general meeting for an ordinary resolution. If it's less than $3,000 collectively, committee can do it. And again, I suppose I'd be saying the same thing. Practically, if everyone wants the gate, then who's going to squeal?
Okay. And how specific does it get? I mean, you mentioned changes in colour of the paint even. If you were to replace a fence with a timber fence, but you use, say, a different timber, does it come down to things like that or not so much?
Oh, I don't, treated pine versus oak, maybe. For like, I suppose, is oak like for like with treated pine? I'd say probably no.
Yeah, I mean,
I'd say no.
Yeah, different colour of cream seems fairly specific to me. So
no, it's and I think that, and maybe the macro view on that is it's changing the way the building looks substantially from the colour scheme that everyone had. So again, that's that sort of, to me, a little bit of the just and equitable type stuff. But yeah, I think probably if the materials you're replacing with, the fence still has equivalent materials in the market today, and you use those materials, no brainer, that's maintenance. To the extent you change those materials, then that may well be an improvement. And I suppose particularly if it costs more. But even so, if it costs less, like destroying things can be an improvement. Removing a spar is an improvement to common property, even though it's the removal of something, because by definition, it's changing. It's not like for like.
Okay. And so do you find, I mean, it seems to me when you've mentioned it, not many things would fall under that maintenance section if you're doing anything around, because I mean, usually would you be changing the materials when you're doing things? I mean, if you're repairing a spa, you wouldn't think that you'd be using the same tiles and you're putting exactly the same spa in as you would
it's probably that characterisation of like for like. Is it like for like? So is it, and maybe part of it is the degree of difference from what was there to what is there. So, maybe we've got tiny little, those blue spar tiles that are 1 centimetre by 1 centimetre, and we're suddenly going to big 3-foot things. Still tiles, but they're not the same. So that changes the appearance. It might change the vibe, and that to me then sort of pushes towards the improvement element of it. But there's a lot of grey. Don't get me wrong. This is, and from a legislative perspective, as you can see, a non-structural change, i.e. installation of an air conditioner. That's all we've got. So is it a change? That tile example? Probably yes.
Okay. Oh, gee. Yeah, very complicated. I'm glad that you've brought it up.
Typical body corp, there's 50-odd thousand body corporates in Queensland that probably charge along without any of these issues every other day of the week. So if a tree falls in the forest and no one hears it, does it make a noise? But when it does make a noise, they become very emotive disputes, as always.
Fair enough. So you've mentioned it was when were the spending limits established and when did they last change? So you were mentioning it was back in the,
1997.
1997. As you were saying, that's changed quite a bit from a cost perspective, especially with all the inflation that we've had and the price rises. And when you were mentioning about getting 2 quotes and making sure that your quotes are submitted as well, I would just say that there's a real difference in timing with quotes these days, and things go up rather quickly as well. So you have to be aware of that.
And currency of quotes. People are putting real strict time limits on them. So, you can't get one and sit on it for 2 months, because by the time you have the meeting, it's probably expired.
Yes. Okay, then we had the question, why don't the limits rise with inflation, or why haven't they been subjected to a periodic review? So you've kind of touched on that a little bit as well.
Yep. And you look, penalty units in Queensland go up every year. So, they describe, speeding might be 100 penalty units. So every year the penalty unit changes. So in a sense, what the government gets as fines goes up every year without fail. Not so much in this space. And I think that has been a conversation that's been had over the years with government. So it's just a function of, and one of the things, in one sense, I suppose, is the certainty around what this stuff is. Because again, even like this little topic has, who knows, dozens, hundreds of adjudications over the years, characterisation, this, that, the other. The Commissioner's Office, which still is a very unique Queensland thing that provides all of the information to owners, to the extent it changes every year, it's just one more thing that has to go on a website that then isn't necessarily accurate the day it happens. And it's hard. And having been through, I've been sitting at the table with the law reform process, and it's probably got a far greater appreciation of the difficulty in drafting, because in a sense, there's part of me that is, this is a nanny state with all these rules. And I think I've got to the stage now where I've probably come to the other side of the fence, where we're saying to people, okay, if you think it's a nanny state, how about we go to a place where there are no rules? See how that works. And I think that is a less palatable option. So yes, that's good for lawyers, and I get that, but some of the bastardry we see from everyone in bodies corporates, this is what the rules are there for, and that's what adjudicators are there for, to stop, these are proper fights and proper issues.
And one of the things is the GST in there too. And I was going to ask you about that. I thought that was interesting that you mentioned that it is inclusive of GST, and someone else has just put a comment up, opinion as to whether or not the spending limits are inclusive or exclusive of GST. Inclusive. Because
it just says $3,000. It doesn't say $3,000 net of GST. It says $3,000. Because again, this legislation was drafted before we had GST.
For lot owner improvements, the committee authority limit is $3,000. If a lot owner is doing, say, a kitchen renovation for $10,000, does the body corporate have to consider the whole cost of the renovation, or only that part that impacts the common property?
The latter. So that spending limit is for a lot owner improvement to common property. So if they're renovating their kitchen, which is their lot alone, then to me, what they want to spend, they want to go put in, I don't know, Calicut marble. That is $15,000 a slab. Go for your life. Nothing to do with the body corporate.
And then we had, if a renovation or construction project exceeding the major spender limit has been approved by owners at a general meeting and a special motion is approved for a loan to fund the project, does the committee need approval to make early repayments of the loan if those repayments exceed the major spending limit? Please note that the motions passed at the general meeting do not impose a specific repayment timeframe or schedule, and the expenditure has been authorised through an ordinary resolution of the body corporate in accordance with the regulation module.
Okay, I'll caveat this one's got to depend on the terms of the loan agreement, but my gut feel on that is that as much as the motions passed at general meeting don't impose a specific repayment timeframe, surely the loan agreement does. And so the body corporate resolved to enter into the loan agreement. The loan agreement said that it's going to be 5-year term at $5,000 a month or whatever it might be. So I think making a change to that loan agreement would be, to me, something needing body corporate approval. So it's not for the owners in general meeting. Again, very caveatable in terms of I need to see the detail, but my gut feel would be owners decided to borrow X dollars at X rate for X term. If the committee wants to change that by repaying it early, you'd need to go back and get authority to do so.
Okay, thank you. And we had a question that came in chat. Why is it a problem to improve something if at the time of maintenance it's discovered that there is a better product that would reduce the ongoing maintenance costs?
Well, it's not so much a problem. This is what the legislation says. So I suppose part of that is what your due diligence should be in terms of, are there alternatives out there? And, from a pragmatic perspective, you would think that if there was a change that reduced costs or increased utility or whatever it might be, that is an improvement as opposed to maintenance, then that shouldn't be too hard to get across the line with owners in general meeting as needed to pitch it. So it's I suppose the government has sort of said, here's what committees can do, here's what committees can't do. And so they've made the decision, right, wrong or indifferent. If this is where committee limit stops. If you want to go and do something different, then you need to go and get owners' approval to do it. So you'd think you think that'd work, but the act is the act.
Okay. All right, and then we've got upgrading firewall penetrations, fireproofing, and/or adding firewalls that are missing from construction an improvement or maintenance?
Well, I think it's going to be an improvement, but it's also one that, from a body corporate statutory perspective, it can't avoid doing. So that in a sense is improving common property to comply with whatever fire safety requirements are. So again, that to me, and even from a committee perspective, it's something that should be done quite clearly. And it's something that QFES, if they knew about it, would be issuing show cause notices or whatever it might be. So what I'd be saying to a committee that sought my advice on that about, can we just do it? Say, what's the harm in getting proper quotes, going to general meeting and getting the approval from owners to do it when it's going to say, when it's 30 days later, as opposed to charge on with something and expose yourself to risk in the sense of criticism from owners for doing something that probably hasn't been right for years. Another 30 days for the sake of getting it right isn't, in relative terms, that much of a problem in my book for something like that.
Mm-hmm. And we were asked, if the balcony is on title, can the body corporate decide to paint your walls a colour of their choice?
No.
Okay.
That'd be my gut feel. It's sort of, I suppose that's then going to be readily observable. I mean, you want consistency. Actually, maybe I'll reframe that a little bit. You're probably back to bylaws and you're probably back to external appearance. That's an arguable one. I don't think if the committee decide that everyone's wall's got to be black, you've got to go and paint it black, because that's still your domain. But by the same token, if you're changing your lot in a way that alters the way the building appears to everyone else outside, then I think that's something that should be driven through the bylaws to committee for approval, so that you can't go paint it black when everyone else is beige.
Okay, that would make sense to me. And we had another one quickly that came in. Our self-appointed committee is approving everything based on their 6 votes only, and the owners have no say in any decision making since they do it by VOCs. Do not get 2 quotes, spending frivolously on their units and not following the laws. It seems to be no consequences for the committees behaving badly and unlawfully.
Oh, there's absolutely consequences, but you've got to take them on. So it's first rule of Fight Club is get on committee. If you're in Queensland, there's 6 members there. There's a spot for a 7th. And then, and this is one of those things that back to that, what committee authority extends to. If the committee's doing things that they are entitled to do and they have been voted in by owners to do that, then right, wrong, or indifferent, that's what's going to happen. If they're breaching their spending limits and spending money inappropriately or whatever, then that's to me, self-resolution first from a commissioner's perspective. Hey guys, boom, 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 and you've got to be very factual about that stuff. It's not emotional. You don't want to be defamatory. I don't think you're doing the right thing. This is what I believe you're doing. Here's the evidence of it, et cetera, et cetera. And if they don't do that, then that's what the Commissioner's Office is for. And financial malfeasance is a really big thing. You know, they don't like that at all in there.
Well, thank you so much for joining us today, Frank. It was great to have you on again.
Bye all.
Bye. If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.